Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello and welcome to the program. My name is Justice Maduforo. I am a solicitor of the Senior Court of England and Wales and also a barrister and solicitor of the Supreme Court of Nigeria. I am Police Station and Magistrate Court Duty Solicitor of England and Wales, which means that we represent you free of charge at the police station, in the Magistrate Court, in the Crown Court, in the Supreme Court, subject to means testing. But the police station is free of charge irrespective of your income. But your income will not be assessed when the matter goes to the Magistrate Court, goes to the Crown Court, and in certain circumstances, if matters that go straight to the Crown Court, you get it automatically. So this is what this program kickstart your consciousness to ensure that you take the right step and go to the right place and get it done once. Tice Madox Solicitors has a cardinal goal and principle, and that is anchored on one phrase: in your best interest. So this program signposts you to Tice Madox Solicitors so that you can come for a well-tailored consultation, and whereby from there your case will be properly analyzed, presented to you, and the roadmap to success laid out and is clear to you on the road and on the target that we are expecting to achieve. On that note, ladies and gentlemen, whatever I discuss in this program, they are not legal advice, but rather you must seek proper legal advice before you can act on what then I've advised you. But you cannot act on what you hear me speak on this program. I have brought you topics and I've discussed criminal matters, I've discussed employment matters, I've discussed civil matters, contract matters, family matters, immigration matters. I've discussed them here. These are where our strength lies on. This is our expertise in the field of law. As long as law is concerned, I have the eagle eye to understand and to interpret and to run through the law and serve you justice. That is what you need. As a matter of fact, you go to the expert that knows their onions, that know exactly what they are doing. Not the try and error experts. We are experts in the field of law that can analyze your case, not just tell you the chances of your success, and in that case we anticipate the success, and also guide you on the roadmap to achieve that success. That is what you need. That is what you need, and that's what you're looking for. Then you have it. Pass the telephone number to whoever that needs legal advice. Of course you do. In all fields of play, as long as you wake up in the morning, you need legal advice. As long as you're working, as long as you're employed, as long as you enter into contract, as long as you're self-employed, you need legal advice. As long as you walk on the road, you need legal advice, even in crime. If it's not immigration, you need legal advice in other areas. So don't feign that it's not for me. Don't switch and just move in and say, this is not for me. No, it is for you. It is for you. And it is for you. Today, I'll be discussing immigration. And the reason I'm discussing immigration today is as a result of a very wonderful development, positive development from the stable of the Court of Appeal, and that it affects your application in the United Kingdom. It is a wonderful outcome, which obviously I had long anticipated, but on Home Office have applied it wrongly since 2014 to date, even 2012 as a matter of fact. They've applied it wrongly from 2014 down to 2016 December. But alas, the stable has changed. The Court of Appeal has turned it down to now present what we have been clamoring, pressurizing on, submitting on, arguing on to be the right principle under the international law. My topic today is updates on proxy marriage. Update on proxy marriage. What is proxy marriage? First, what is proxy? Proxy is where you are not there, but you have sent your proxy. You've sent your authorized agent to embark on a certain legal venture on your behalf, and as if you are the one that done it. So, through the power of attorney, you have conveyed or given authority and another person to enter into a legal binding transaction on your behalf. So proxy could be in any way, in a contract, in anything at all you can think about. But I'm talking about proxy when it relates to marriage. Now, what does that mean now? Proxy marriage, now all in one word, is that transaction whereby you marry your spouse under the customary or traditional law where you come from. Africa generally has laws, customary laws, sitting side by side with the rest of the laws. So customary laws in Africa shape the main laws of the land. So a special attention is given to customary traditional laws, especially in Africa, and obviously from other part of the world as well. But more especially in Africa, the customary laws sit close to the regular conventional laws. So they shape the regular laws. So the courts have come to endorse it. The laws in the parliamentary and House of Assembly and the House of National Assembly of each country have also come to endorse it. The parliament have come to endorse customary law. Now, I'm going to be using a case study to discuss this proxy marriage. And I want to use Nigeria as a case study in discussion of this proxy marriage. But remember, none of this is legal advice. But they are legal matters of which you can regularize your stay, regularize your family life. So proxy marriage is not only in regularizing your stay, also regularizing your family. Assuming you do not need to regularize immigration rules, regularize your immigration status. You can regularize your family life. If you already here a British citizen, both of you as partner and yourself, but you come from Africa, your ancestors are from Africa, you are descent of Africa, you want to abide by the customary law of your fathers or your forefathers, and you want to marry your wife through that means, then you can do that and regularize your family life. In that case, both you and your wife are not seeing each other as a legitimate family life. That's what it is, yes. But for those of you who are applying to marry, to regularize a stay in the United Kingdom as a result of your partner or your spouse who is either a British citizen or who is an EU citizen, and either of you is a non-EU citizen, so the proxy marriage will take place. In that case, you become a family member of this individual. So it's very crucial to you understand the technicalities that are involved here going forward. As I said, prior to 2016, the Home Office have applied the wrong principles under the international law as it applies to proxy marriages. Now, the international law allows that a country can legislate under customary laws as long as it is legislated and endorsed and accepted by that country. Then any other country where it is presented to must accept it. In this instance, I'm also using a case study, Britain. So Britain, or United Kingdom as it is, will abide by the customary law entered into in Nigeria as a case study. And so as a result of that, it will see you now as a family man, family woman, family life going on within yourselves. No longer partnership, but you have transited from partnership and have entered into a customary marriage now from Nigeria as a case study now. And then you will now present yourself to the Home Office in your applications as a family member, as a family life going on with your spouse. Ladies and gentlemen, the laws have been wrongly interpreted from 2014. In the case of Karim, the Home Office have chosen that field. Inasmuch as petitioners, we have warned and submitted and argued that that principle was wrong. That principle is not correct. But Home Office have carried on with it, and the courts, especially the upper tribunal, has endorsed it as the right principle, which means that the country of your spouse, who is an EU citizen, will have to endorse again that proxy marriage. The Home Office is saying, for instance, yes, we accept your proxy marriage, but your partner or your wife, you said, who is from France as a case study now. Remember, I'm using these countries at random for case study purposes and for analysis purposes here. And the spouse is from France. The Home Office, when you make the application, you're from Nigeria, your spouse is from France, be it the man or the woman, and you marry by proxy, and you live in the United Kingdom. United Kingdom will say under the old rules, yes, we accept your proxy marriage, but you have not shown that France have accepted that. But that is not what international law has been advocating. That's not what international law interpreted. So it has been interpreted the wrong way. Doesn't mean the courts don't get it wrong, but when they get it wrong, they still have the onus on them. And when it's properly presented before them, and they see the reason, and especially with the dynamic nature of life, they must have to review that decision and upturn their own decision. Now, as a result of that, the Home Office have clamored and have turned down applications, thousands of them, on the basis that your marriage has not been properly regularized, which means France now has not endorsed that marriage. The citizen, or your wife, who is a citizen of France or who is French, has not been, French authorities or embassy in the United Kingdom has not approved that marriage. Therefore, your marriage falls flat. The Home Office refused the application, even if you meet all other requirements. The Home Office refuses it. Now, that has been ongoing. Now, the other arm of it is the registration of the proxy marriage. Now, I'm going to talk about that registration shortly, but let me dwell on clarifying why the Home Office has been wrong all this while in advocating and the court following through that such marriages will have to be endorsed by the country where the woman hailed from. It's a wrong principle. Wrong principle. That's the case of Karim. So Karim has destroyed so many applications and ruined so many families. But the good news now, the good news is that if you have been refused application under the EU, under the EEA application or EU application to regularize a stay as a family member of an EU citizen, under the old rules, and you're hearing my voice or somebody is hearing this or listening or watching this telecast either on TV or YouTube or on our Facebook page, and you really want and know someone who has gone through this, the only favor you can do to them is to say, watch this channel or take this telephone number. I think they can help you. And they can come to us so that we can overhaul their case and represent it again. Now for success. Because what that means is that all the decisions done in the past has been refused on error. Yes, refused on error. And the challenges for most of you non-EU citizens who do not have right to marry here becomes a problem. How you can marry under the civil law or through the Church of England or through the appropriate channels. You couldn't because of your lack of leave to remain in the UK. And so out of a fear of the fact it's not possible, you have decided to stay on this while. Listen, good news. Good news. It can only be said good news. You only have to sit up now on, even if you haven't done it in the past and you're intending now to marry your spouse or your partner or your girlfriend. Yes, that can be done through proxy marriage right now. This year, 2017, the Court of Appeal has now changed that old principle. The Court of Appeal has now reviewed that old principle, that old law, that has been wrongly judged, and has now agreed that the law of the country where the customary marriage took place is the only law that is required to prove that that marriage is entered appropriately. And under the international law, the country, the receiving country, which is the United Kingdom, must accept it without asking the partner who is from the EU citizen to provide proof from the country from her country to confirm, a written confirmation, as a matter of fact, to confirm that they also accept the proxy marriage. That is turning the international law upside down. But now the Court of Appeal has reverted it and placed it in the right perspective it should be, which means that the law that's required is the law of your country. So if you're from Nigeria, Ghana, Cote d'Ivoire, Mali, where you practice, whatever country, you practice customary marriage. Now, once that country accepts that customary marriage, United Kingdom is stopped under the principle of estoppel from refusing or refuting that marriage. The only thing left now, which some of you will still get it wrong, that's why this telecast is for you. That's why this program is for you. The only thing, most of you will run widely now for the sake of saving funds. You will run quickly and then start entering into Proxy marriage, and then you get around the way, you stop again. It's now fulfilling the requirement, which is very stringent in your country, to make sure that that Proxy marriage was entered correctly by the registrar of that customary court or traditional court, whatever name that you give is given to your country that abides and upholds customary law or traditional law. Now, the question is that, what are the ingredients? Have you fulfilled the requirement? When you come to Tice Madox Solicitors, not only do we guide you with all the requirements to fulfill, so that once these are all harnessed together, your application is done once and you get it once, ladies and gentlemen. Ladies and gentlemen, that is what you need. That is what you need. You need the firm that will guide you so you can go home relax that you've come to the right place. We argue with you all the way. You see, when we prepare applications for you, we don't just prepare application just for the sake of now. No, we prepare application and watching the Home Office. If you make any mistake to refuse this, we have infused sufficient evidence, sufficient argument to take you on. That's what it is. That's why you go to experts. Experts will not only argue the case for you, present it the way it should be, but also argue in anticipation. In anticipation. In anticipation, just like an architect. An architect will design a house for you. The foundation will probably be fortified in anticipation that you may want to put up another extra floor in future on this building. And so the foundation can carry it. That is what experts do. They take into account your journey in the now, in the future, and push it all together. So at any point in time, there is some flexibility you want to amend. So anything that you need to change, you can still be within the right frame. In legal matters, in applications, in arguments, in appeals, in tribunals, in first tribunal, upper tribunal, in court appeal, what we do with argument to fortify is argument not only on the common law, argument on technicalities. Because I've discussed this on this program. Sometimes technicalities take the day away from common law principles. Common law principles is the tick box. Have you got this? Have you got this? Have you got that? These are common law. But technicalities, which is now part of equity, goes to show that it is contrary to natural justice, equity, good conscience, to refuse this application. That's where the question will be propounded strongly enough that can bring down the common law tick box approach to substitute it with those valid questions that we pose when we make applications for you. Ladies and gentlemen, it is real. It's a real deal. It's a real deal. When we present to you, not only applications we make for you, but when we argue your cases in the first tribunal, upper tribunal, employment tribunal, employment appeal tribunal, in the magistrate court, crown court of justice, in the court of appeals, high court of justice, in the Supreme Court, in all other tribunals, be it professional tribunals, be it traffic tribunals, and all the tribunals, ladies and gentlemen, you have no more excuse because you do not have the right key to open the door. So you don't need to be trying all keys to open the door. You have been given the one key to just slot it in through the hole, turn it anti-clockwise. The door is opened. We'll give you the right key. And the right key is Tice Madox Solicitors, where the right application is made, the right appeal is lodged, the right argument is propounded, the right judicial review grounds are propounded, the right advocacy is put on your behalf, the right matter is done on your behalf. If you go into bankruptcy, the right challenge under the Insolvency Act is argued for you. Ladies and gentlemen, you have no reason to have any excuse if you are listening to the sound of my voice and watching this program, either on the screen or on Facebook or YouTube, because you've been given the right key. So why would you want to throw away the right key and then have a bunch of keys that you're making errors, trials and error, which one opens which? You waste your time. You've given the right key to open it and walk into the house, open the fridge, have a nice glass of water, a nice clean ice-chilled water, and rest in your beautiful sofa. That is what we do for you. We present soft landing for you. That not only will things work smoothly for you, you'll be relaxed. So I created that analogy and that metaphoric explanation to show you what we do for you when we represent you. Ladies and gentlemen, we are strong, firm professionals. We are thorough. We are thorough, completely thorough, from the beginning to the end. When we start from you, you know where we end. We don't leave you halfway like others do. We guide you to the end. We write to you. We communicate with you. You will understand what we are doing for you from the beginning you step into our office. So you are not going to be met or be given so many scenarios that you never discussed now. Because it's what we do. We know the journey through and through. So we know which of the areas and all the journeys that we embark with you as long as the legal matters are concerned. And will advise you accurately and correctly. Back to my topic. Updates, proxy marriage. Recently, as I said, the Court of Appeal has not changed that. It is now the fact that the country, your country, that African country, that European country, that Asian country, that non-Asian countries, that South American country, their law, as long as they have customary or traditional law, as relates to marriages and as relates and endorses it in terms of proxy, and it accepts that in terms of proxy. And once that has been done and registered properly, then United Kingdom, where you reside for the purpose of this telecast, is United Kingdom, will have no excuse, will have no reason to question that marriage. Will have no reason to question whether your partner, who is from EU country, has been approved. Now, the case of Awuku have changed all that. And that's why I presented good news to you, that you need to think back. If your application has been refused in the past and you still have not started it forward, you can come forward and we can resurrect it all fresh again. As long as you are still in a relationship with your partner. Because if your relationship has broken down, obviously you cannot go back to this and take advantage of this new law or this new case law. No, you can't, because the relationship has broken down. But if the relationship is still on and you are still living on as partners, then that is a good news for you. This case can't come back alive. It's back alive. And if you're intending to, because you have a girlfriend or partner who's an EU citizen or British citizen, and you have not been able to come together as a family by way of a proper, registered, legal, documented marriage, then the opportunity for you to take this action and your marriage will still be sound and genuine. And you can make an application here in the United Kingdom with that certificate or with those certificates, and that will be done for you. How do we embark on this? The telephone is on the screen. We have a YouTube page where you can go subscribe and listen and watch us. Remember, they're not legal advice. They're all kickstarting your consciousness with all different topics that we put out there for you. Ladies and gentlemen, and also on Facebook, you watch us. Tice Madox Solicitors. You can watch us. All the programs we put on there. Ladies and gentlemen, on our Twitter handle, you can see our Twitter handle, Tice_Madox. Ladies and gentlemen, at Tice_Madox. And also, you can also go to our website, ticemadox.com. You can get all that we do. You have no excuse. You have absolutely no excuse, because you are in the right place to lead you all through and through. So, ladies and gentlemen, this change is crucial. This is what I've been advocating and talking about. The law is flexible. Laws can change. If it was against it today, it will turn around in your favor tomorrow, because petitioners like us have kept on pressing the court and saying to the court, this principle of which was in the past is not correct. Because every human life is dynamic, and therefore you cannot use one case law to destroy the others. Cases are on individual basis. Circumstances varies. They're not the same. And so we continuously bring it before the attention of the court to change the decision they made themselves, correct themselves, which is what the Court of Appeal has corrected now to be the right principle as long as relates to proxy marriage. It has corrected that. The same was done also in applications in the past, in criminal matters, for instance, when it relates to murder, conspiracies, or joint enterprise. The Supreme Court lately, last year 2016, corrected that old principle and is now the right principle when it comes to joint enterprises, how to threshold to prove joint enterprise when it comes to murder trials. This is the same way the Court of Appeal have also changed the principle that been in the past in this case of Awuku. Therefore, your case is alive. Not only do we do immigration, ladies and gentlemen, it's good at that point that you know that very well, but we present this topic to those that are in their need of them. When it comes to criminal matters, family matters, employment matters, you have us to run quickly with you and fulfill the responsibilities that we owe you, which is to represent you in your best interest. I wish I could go on and on and on. Unfortunately, you know this is not a legal advice program. This is just a program to state your consciousness. And I have done that right now in this particular field, in this particular area, in this particular legal field I just discussed with you. If it doesn't apply to you, it applies to somebody else. Pass the telephone number to the person. Pass the telephone number to the person. Direct them. Signpost them to Tice Madox Solicitors, and they can get the best representation they need. I remain your usual host, Justice Maduforo, your preferred solicitor. And of course, Tice Madox Solicitors, your preferred firm. Till next time I come your way, I say, be strong.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.